Okay, great. Good evening, welcome. I hope you're all doing well. Test marks have been entered on the kiosk. Hope you've all checked. In general, class average was fairly good. I was quite happy with how you did in the test. The tests for the Windhoek students, tests have been placed on the counter outside my office. Those of you that don't know where that is, that's on the third room 313 in the office building, directly opposite the lift. So you can collect your tests there if you're interested. As for the students that wrote in the regions, test papers will be returned to Department of Student Support, who will then send them back to the various regional offices where you wrote. We need to do Unit 11. We've finished with lease agreements. So far we've done the law of contract in general. We've done specific contracts. We've looked at purchase and sale and lease agreements. Please be careful. I find very often that students tend to muddle lease agreements and purchase and sale. They confuse the two contracts. Don't quite understand why, because in real life, surely you know what the difference is between buying something and renting something. I recently saw an answer. It was in one of the tests that I marked, but it was a full-time student. A student wrote something in the line of, when you lease something, you buy it with the intention of giving it back later. Now, I found that very strange. Surely you don't, that you know what a lease agreement is. When you rent, guessing most of you live in rental properties at the moment, that is a lease agreement. Buying a loaf of bread is purchase and sale. Having said that, it's time for us to move on to another special type of contract, which you might not even have realized. You might not even realize that this is actually a contract, namely agency. But agency also arises from a contract. Let me just share my screen. Okay, just give me a thumbs up if you can see my screen. Okay, lovely. It is the same set of notes that I've been making that I used for lease agreements. In due course, I will also, like I did previously with the first set of class notes, I will share them with you as well. So the law of agency. Now, I need to warn you in advance that this unit, the understanding of this unit is very, 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 very important. Not so much for assessment purposes, also for assessment purposes. But after this unit, we move on to partnerships and the principles of agency. become very relevant when we study partnerships. Next semester, you'll be doing company law, and similarly, the principles of agency are also relevant and pertinent to company law. So it's important that you understand these concepts, because when we get to them in partnership, within the context of partnerships or companies, I'm going to remember that I taught you this. And I will expect of you to have understood and to understand and be able to apply these concepts. I'm not going to teach them to you, explain them to you again when we get to them within the context of partnerships or company law. So what am I talking about when I refer to agency? Let's use some simple examples. Let me just think of something quickly. Let's say I have an account at Ackermans. I don't, but let's say I have, for the sake of example, have an account at Ackermans. So one fine day, I want a new dress. And I sent Rocher to go to Ackermans because I'm busy, I don't have time. I know Rocher is an immaculate lady with exquisite taste. She'll know what I like. So I sent Rocher to go to Ackermans to buy me a dress and charge it to my account. She does that, and at the end of the month, must I pay for this dress, yes or no? Come work with me. I sent Rocher to buy me a dress and charge it to my account. I get the account at the end of the month. Do I have to pay for it or no, or not?
May you please repeat that question again?
Okay, George. Let's repeat that for the sake of everybody. I need you to work with me, please. I have an account at Ackermans, and I send a lady, Rocher, to go and buy me a dress at Ackermans. She does that. She selects a dress for me. She charges it to my account. She gives it back to me. And at the end of the month, I get the account from Ackermans for this dress. Must I pay this account? Yes or no? Bearing in
Yes.
mind, I didn't go and buy it.
Yes, you must pay for it.
I must pay for it.
Yes.
Exactly. What happened here? This whole transaction is a simple illustration of the concept of agency. How do we define agency? And to just copy and paste here from the actual notes, save some time. Agency is when a person with the necessary authority, known as the agent, concludes a contract on behalf of another person, known as the principal. So what happened in this scenario is I sent Rocher to go and buy the dress. She went to buy the dress. She contracted with the shop. But because I instructed her to do that, she is not required. There's no contract of purchase and sale that comes into existence between her and the shop. In fact, the contract was between me as the principal and the shop. She is literally the go-between, so to speak, the agent. Sure, you all know the word agent, and that's pretty much, it doesn't, in law, it doesn't have a different meaning to what you come across in ordinary life. Now, in order for the principal, so that was me in the example, to be bound, obviously this is law, so like always, there are requirements. What are the requirements for valid agency? Requirements for valid agency, there are 3 of them. First of all, the principal must exist. This might sound strange to you at the moment, but it becomes relevant when we do company law. The fact that the principal must exist. There must be a principal, otherwise there cannot be any agency. The agent must be authorized. We're going to get back to this one. And then the agent must inform the third party that she is acting as an agent and not in his or her personal capacity. That one is also not that extremely, but it does become relevant. But this is the important one. This is the important one. Also, here in the definition, agency arises when a person with the necessary authority concludes a contract. There can be no valid. Yes, George?
Those are the requirements of what again? Can you please repeat that?
Those are the requirements for valid agency.
Thank you.
So in order for the principal to become bound to the contract, to have the rights and duties in terms of the contract with the third party, as opposed to the person who concluded the contract. The principal, that's the person that gave the instruction. The agent is the person that concluded the contract. But the agent concludes the contract on behalf of and with the authority of the third party, with the authority of the principal. And the agent is just the go-between. The agent does not incur any rights and duties. Roche went to buy a dress for me. Roche doesn't get to keep the dress. She doesn't become liable to pay the account. She's just the go-between. But now let's look at a different scenario. One fine day, let's use somebody else. Naomi. Naomi walks into Ackerman's and sees a dress that she thinks might look good on me. She takes it from the shelf and goes and charges it to my account. She comes back, she gives it to me, but I don't actually like it, so I don't accept it. Must I pay for that dress? What do you think? Benjamin, what do you think?
No, ma'am, you are not liable for paying for that dress since you didn't inform her to go get a dress for you.
Absolutely, 100%. It is as simple as that. In fancy legal terms, The agent must be authorized. I did not inform her to go and get the dress. I did not give her an instruction. I did not give her authority. She just did it randomly because whatever reason, and because there was no authority. I am not bound. I don't have to pay it. It's as simple as that. It's actually just total common sense. Now, with regard to authority, there must be authority. In order for the principal to be bound, there must be authority. There are different types of authority, and you need to be able to understand these different types of authority because they become relevant when we apply them to partnerships. First type of authority is actual authority. And there are two types of actual authority, namely express authority and implied authority. And you need to know the difference. You need to be able to distinguish between express authority and implied authority. The easiest way to understand the concept of express authority is that it is a specific instruction to enter into a specific contract. So when I went to Roche and I said to her, Roche, please go to Ackerman's and buy me a dress. That is express authority that I gave her. A specific instruction to go and do something for me. Implied authority is authority that comes with a job. Very often, and some of you might be in this position, very often when you are in a particular position, you've gotten a job, and that job requires you to enter into certain contracts on behalf of your boss. Let's say Apollonia is my personal assistant. And part of her duties as my personal assistant is to make sure that we always have the correct and the necessary stationery in our office. It's part of her job. When she sees we've run out of whatever stationery, she needs to go and buy it on behalf of the office. She doesn't pay for it personally, the office pays for it, but it's part of her job. So she can validly bind the principal, the office, because she has authority, implied authority. So I don't have to give her a specific instruction every time. I don't have to tell her on a Monday, Apollonia, go and buy paper. And on a Wednesday, Apollonia, go and buy pens. And on Friday, Apollonia, go and buy paper clips. It's part of her job. If I told her, Apollonia, go and buy paper, that is express authority. Given her authority for a specific contract. but doing it, checking, okay, the stationery cupboard is empty, we need paper clips, pens, putting in an order for that. That's part of her job. It's part of her duties. It's implied authority. When we get to our further studies, we will look at the implied authority of partners in a partnership. Next semester, we'll look at the implied authority of company directors and members of a close corporation. They all have various levels of implied authority. You don't need to stress about that now. We'll do that in more detail later. What you need to understand now is implied authority. So, does everybody so far understand the concepts of express authority and implied authority? In both instances, these are both examples of actual authority. Oh, sorry, I've got a bit of a cough. These are both examples of actual authority, and accordingly, the principal will be bound. Let's put this in here. But what happens if there was no authority? We've seen so far that in order for the principal to be bound, there must be, the agent must be authorized. So the opposite of that would be that if there's no authority, that means will not be bound. So far, so easy, but unfortunately, it's not quite as easy as that, because there are some exceptional cases where a principal that wishes, or a third party that wants to hold a principal to a contract can, but there's no actual authority, can make use of apparent authority. Be very careful though. Apparent authority in practice is difficult to prove. Let's give you an example. Let's say that Apollonia was my permanent secretary, not permanent, personal secretary. She had authority to buy stationery for my business at ABC Stationers. Then one day, now listen carefully, she stops working for me. And of course, the moment she stops working for me, your common sense should tell me then she can no longer buy stationery on the business's account. Now she's stopped working for me. But I do not inform ABC Stationers that she's no longer working for me. So they believe that she is still allowed to buy for me. Then she goes and she buys a lot of stationery for her child for school. And she charges it to my business account. Must I pay for it? Yes or no? What do you think? Yes, Benjamin?
Yes, you have to pay for all she has taken.
I agree with you, but why do
Okay.
you say that?
Since it's your failure to inform now the third party of her departure from your business.
Absolutely, absolutely. I'm going to type out the legal terms soon. Let's use a different scenario.
Yeah.
Naomi has never worked for me, never bought anything for me. She goes to ABC stationers and buys stationery for her child. Must I pay for it?
May you please repeat the question, ma'am?
Benjamin correctly said, you used to work for me. ABC station, and I always paid. ABC stationers knew you were my employee. Now you've stopped working for me, but I don't tell ABC stationers. And you buy stuff for your personal use. Must I pay for it? And Benjamin correctly said, yes, I will have to pay for it because I didn't tell ABC stationers that you are no longer my employee. And when they sold the stuff to you, they thought you still had authority. Are you with me so far? But now Naomi has never worked for me, never ever. And she goes to ABC stationers and buys a whole lot of stuff for her personal use. Must I pay for it? Yes or no?
I would say no. Whereas, yeah, I think the same principle applies as to what Benjamin said. They don't know that Naomi works for you now, so they would definitely need some sort of confirmation from you that she's now the new employee.
Okay, well, in my examples, you're quite correct. In my example, she wasn't even the new employee. But you're correct. If she is the new employee, I will have to inform them. She isn't even the new employee. She's just a random person that went and bought on my account. Answer is still the same. No, I don't have to pay for it because she didn't have authority. Marilyn, your hand is up. What do you want to say?
Good afternoon, ma'am. No, I just wanted to ask a question regarding to Naomi going to buy stationaries on your account. Now, the ABC, are they allowed to sell the thing or to give the stuff to Naomi without your authorization? Is the person that is authorized not already on their system? I just wanted to
Marilyn, that's from a practical point of view, that's a valid question. The fact that they sold it to her, they weren't allowed to do that. They were stupid. So now they are going to suffer the financial loss because I am not going to pay for it. Whether they're allowed to or not, they decided to ignore that and just sell it randomly. So their problem, they lose their money because they can't hold me to the contract. Are you with me?
Okay, ma'am. No, I understand now.
Yeah.
Thank
So
you.
from a business point of view, for them to sell stuff to a random stranger, without verifying, may we do that, is, from a business point of view, was a careless and a reckless and a stupid thing to do. They shouldn't have done that. Any further questions before we go to the legal terms here? Okay, so what has happened here is there was no authority when Apollonia went and bought this stuff for her own use while she's no longer employed by me. She had no authority. Similarly, when Naomi, random stranger, bought the stuff, she had no authority. But as Benjamin quite correctly said, in Apollonia's case, they can hold me to the contract because I didn't inform them that she no longer has authority. This is what we refer to in law as apparent authority. What is apparent authority? Apparent authority, a situation where a person, either by words or conduct, represents or permits to be represented that another person has authority to act on his or her behalf. By not informing ABC stationers, as Benjamin pointed out, I allowed them to continue believing. Previously, they were allowed, were in a situation where they believed that she had authority because I was always paying the accounts. Now I don't inform them, so I allow them to continue with this incorrect belief. The principle creates the impression. And I'm not going to use the word agent here, because for her to be an agent, that means she has authority. She's in fact not my agent. So let's use representative. Principle creates the impression or allows the impression to exist. But it's important for the understanding here, for apparent authority, for there to be apparent authority, it is the principle that creates the impression, not the person that pretends to be the agent. When Naomi went in and bought stuff on my account and told them she's allowed to, told them a lie, as Marilyn queried, were allowed to believe this. They were stupid, they did. It wasn't me. It wasn't the principle that created the impression. It is the representative. In that case, I'm not bound. But when I myself, what it comes down to in law, the concept of estoppel, if you create a false impression, you can be held liable. Yeah, let's put it like this, held liable terms. So the concept is not that difficult. Benjamin understood it perfectly right from the start, and I'm pretty sure the rest of you also did. in reality, in real life, holding somebody bound in terms of apparent authority is not that easy. There are requirements and they are quite difficult to prove. Requirements are that, I'm not going, okay, let me type them out for you. The requirements firstly is that the first requirement is that there was a representation made by the principal. And an incorrect, no, let's take incorrect out, sorry, just say a representation. An impression was created. By the principal, that's important. Not by anybody else, not by the middle person, by the principal. This impression that was created must have been realistic. It must have been reasonably expected to mislead. So you can forgive, like the example we used, as Benjamin pointed out, I never informed them. They had every reason to believe. It was very valid of them to believe, to think that she still has authority. They were not being stupid or careless. So the impression must have been reasonably expected to mislead. The third party actually believed this. And as a result, or stand to lose, suffer losses as a result. I'm not going to pay, then they're going to be losing money. So that is the concept of apparent authority. Easy to understand in theory. When you are answering case studies, don't always first, it's easier to prove that the agent had actual authority than that the person had actual authority than to try to rely on apparent authority. But now let's move on to the next aspect. We use the example right in the beginning. We started off with Rocher buying me a dress on my account. You all agreed I'd sent her, she had express authority, I have to pay for that dress. Then I used the example that Naomi went. Naomi went. I didn't tell her to go. I didn't ask her to go. She just randomly bought a dress. And you all agreed that no, I don't have to pay for that dress because she didn't have authority. But now what if she brings me the dress and I like it? I want to keep it. Of course, if I want to keep it, I have to pay for it, but I don't mind. I'm prepared to pay for it. How does this work in law? Concept that I'm talking about is ratification. Ratification is where there was originally no authority. And you understand, if there was no authority, the principal is not bound. So there's originally no authority. The principal accepts the contract. And gives authority retrospectively. So originally there wasn't authority, but because I accept the contract, I become bound to it and I have to pay. That is ratification. Please be careful here. You will lose marks. The word is ratification. It is not. And I will literally deduct marks from you if you get this wrong. It is not rectification. Rectification isn't even a word. It doesn't exist. It is also not, so common mistakes. It is also not rectification. Watch out for the spelling. Ratification. There's no C in it. It's not a rectification. Rectification is something else. It's a different legal concept. So, of course, for ratification, there are requirements as well. Just going to copy and paste them for you. Requirements are that the agent or purported agent not only intended but on behalf of another. So Naomi went and informed them that she's buying the dress on my behalf. They must put it on my account. I can't ratify it if she bought it for herself and paid for it herself. The principle must exist. That's similar to that requirement. You can't represent a non-existent principle. And then in order for there to be ratification, there must be contractual capacity. That's fairly self-explanatory. In order to become bound to a contract, I have to have contractual capacity. Any questions? Short unit, not very much. This is the whole unit. I've basically finished with tonight's class. But the concepts of express authority, implied authority, apparent authority, and ratification, you need to know them You will be required when we do partnerships to apply them to case studies. You need to be able to identify from a particular case study whether there was authority and what type of authority there is. So even though this is a short and sweet unit, don't disregard it. Okay, so that's all for tonight then. Let that sink in. Any questions? If you are traveling for the long weekend, please stay safe. Otherwise, have a very, very blessed Easter. We will have our next class then next week and Wednesday. Monday is a public holiday. There's no class. Next week, Wednesday. I'll see you then. Thank you. Bye.
Bye, Miss.
Bye.
Bye.
Bye.